Hey, everybody, and welcome to Thursday night. Hey, everybody, John Skiba here from the Consumer Warrior YouTube channel, and it's Thursday night. So here we are once again doing the live stream that I try to do each and every week, except for last week. I was out of town, had a family wedding I was traveling to. But I'm back here in the office and grateful to be here with you tonight. I am an attorney in the state of Arizona. I work at the law firm Jackson White, located in Mesa, Arizona, and I do bankruptcy practice. I help people who are dealing with pretty serious debt issues file for bankruptcy. I also represent people who are being sued by debt collectors, junk debt buyers, those kind of people. So what we do each and every Thursday night is we go over different questions that people have. If you have a question and you're on YouTube, you can put that in the chat section. I'll go ahead and put it up here on the screen and we will go over it. My disclaimer that I give each and every week is that I am a licensed attorney in the state of Arizona. I'm not licensed anywhere else. I can't give any legal advice, and nothing that we talk about here should be considered legal advice. I don't know your specifics. If you're outside the state of Arizona, I don't know the laws in every state. And so it's just, I always say, take it for what it is. Some guy on YouTube talking. So take that for what it is. But hey, I wanted to start off tonight with something that is somewhat Arizona specific, and a comment I found on the YouTube channel. And it talks about this Proposition 209. So I'm recording this in November 2022. We just had the election on Tuesday. And one of the propositions in Arizona that passed is Prop 209, and passed by a large margin. I actually did a whole video on it. You can go back and check that on the YouTube channel. I do kind of a deep dive as far as what it is and why I was in support of it. And what it does is it radically changes debt collection in the state of Arizona. It also impacts bankruptcy because it changes the exemption laws that protect your stuff as you go through bankruptcy. It also protects your stuff when you're not in bankruptcy and your creditors are just giving you grief. It did things like right now, the homestead exemption in Arizona protects up to $250,000 of equity. It bumps it up to $400,000 of equity is protected. One really powerful tool is how it impacts wage garnishment. Right now in Arizona, 25% of your check can be garnished if the creditor gets a judgment and serves it on your employer. It reduces that down to 10%. Would be garnished. I was actually at a conference not long ago, just a couple weeks ago, and they were saying that they thought if Prop 209 passed, it would eliminate 70 to 80% of all wage garnishment in the state of Arizona, just because of there's a lot of income-based components to it. It does a lot of things, like protects up to $15,000 of equity in a vehicle. Right now it's $6,000. It'll protect up to $5,000 in a bank account. Before it was, right now it's $300,000. So it does a whole lot of things. And I can tell you the name of the bill was really focused on medical debt. It caps interest on medical debt. Before it was 10%, and now it's down to 3%. So a lot of great things there. Glad it passed. This question I got off the YouTube channel said, when would Prop 209 take effect? I see that it starts being adjustable on January 1st, 2024, but is that when it starts? So this is a good question. And it also brings up one of the other things I really like about the proposition that passed is it has a mechanism there to adjust for inflation. Because part of the problem in Arizona when it came to the exemptions and some of these laws that protect people through the debt collection process, they assign values or the amount of equity to them, but then it becomes outdated very quickly. We've seen this in the last two housing spikes and crashes in 2008. I don't think we'll see the housing crash like we did now, but we saw a huge buildup in 2021 in home values in Arizona. Now it's cooling off and the houses are starting to go down a bit. So when it starts, and this is a surprisingly complicated question. I talked to some other attorneys I know who had talked to some other people they knew, and our best guess is it starts somewhere in early December 2022. So December 8th, 2022. It's based upon some constitutional provisions, which is usually 30 days after it goes in, after the law is voted on. And so 30 days from November 8th is going to put you around December 8th is when they anticipate it's going to go forward. There are some complicating factors, and I can tell you the creditors bar, the creditors attorneys, they are not happy. And I've already heard grumblings that they're going to try to sue to stop this from going forward. So hopefully, things could roll out a little bit smoother than, it sounds like they're going to. But in the end, I do think it's going to provide a lot of relief, particularly from junk debt buyers and some of these creditors that get judgments and then sit on them for a decade and then try to come after it after the fact. So hopefully that is a benefit. A couple other questions I thought would be good to address that are on the my YouTube channel. Excuse me. This one is in regards to bankruptcy. I did a video on preferences, what are known as preferential payments in a bankruptcy. And the idea behind the preference is that if you have money, if you have loans from family members, friends, business associates, and you pay them back within the 12-month period before you file for bankruptcy, the bankruptcy trustee can then go and get those funds back from that family member, from that friend, bring them into your bankruptcy and distribute them evenly amongst all of your creditors. They call them preferential payments because essentially you're preferring those creditors over the others, whether you are not. If you've paid back family members in that 12-month window, they're going to try and go get those. So this person said, why can you pay other creditors just before, and that's okay, but not family members? Such BS. Watch your mouth, man. Why is that okay? Well, here's a quick answer. It's not okay. If you pay back any of your creditors, let's say like your credit cards, you pay them back a bunch of money. If you do that, the look back period is different. And the distinction that the bankruptcy code makes is between insiders and what they call non-insiders. So an insider is family member, friend, that kind of thing. They'll look back over 12 months to see if you paid them back. For regular creditors, for non-insiders, they go back 90 days. And so I have seen creditors, where a client has paid a bunch of money on a credit card or something like that, where they will go back and try to recover those things and then distribute them evenly. That doesn't apply, though, to secured creditors like home loans and car loans. They can't go back and get those. But other types of creditors, yes, they can. So it does apply. Just the look back period is a little bit different. The idea behind that provision of the bankruptcy code is they don't want people just transferring a bunch of stuff to family and then thinking they can file for bankruptcy. That's why I always say, if you're contemplating bankruptcy, status quo. Because I run into a lot of people who say, hey, I'm going to file. I want to hurry and pay back my mom before I go through this process. Don't do that. You can pay mom back after you file for bankruptcy. And frankly, you can voluntarily pay back anybody. But don't pay them back prior to, or you're going to cause yourself and your mom some problems. All right. One last question before we'll jump into the live questions. This one talks about defending a debt collection lawsuit. We talk a lot on the channel about compelling private arbitration. This is a clause that's in the terms and conditions of almost every single credit card terms and conditions that are out there. And it's a way of getting it out of the court system and dealing with it through this private arbitration process. This question on the YouTube channel said private arbitration clause would not be applicable in dealing with a junk debt buyer, only the original creditor, correct? And so in junk debt buyers, by the way, those are like Midland Funding, Portfolio Recovery, Unifund, and any company that buys debt from the original creditor, for pennies on the dollar kind of thing. Well, actually, in response to this, my answer would be not correct. The arbitration clause, which is found in the original creditor's documents, it is enforceable against the junk debt buyer. So you got to remember what the junk debt buyer, what they're really alleging when they file a lawsuit. They are saying, hey, judge, we stepped into the shoes of the original creditor, and they're saying, hey, it's almost like we bought this. And so now we want you to treat us just like you treat them. And so they're bound by all the same terms and conditions as the original creditor. So they can't have it both ways. They can't say, hey, we're bound, we're stepping into their shoes because we want to get all the money, even though we didn't loan the money to this person. We want to be able to sue them and collect and garnish their wages, but we don't want to be held accountable under the other terms and conditions. They can't do that. They can't have it both ways. They're either stepping into the shoes of the original creditor, and thus they're bound by that clause, or they're not. And so if they're saying that they are, and they are, they're bound by it. So you can use it against debt buyers. You can use it against original creditors. All of them will work out great. So, all right, let's jump into the questions. Al is here. Looking forward to future master classes. Hey, and I have got a whole schedule of them that I'm going to put up here this weekend that we're going to start cranking those out. Like I said, I was out of town with some family. I was going to say family issues, but it was a wedding, so it wasn't a family issue. But we're going to have those up. And what he's referring to there is the community of the Consumer Warrior community. I put a link in the chat section on YouTube. It's all my tutorials, but you can sign up there and become part of that community and attend some of those master classes that are for community members only. All right, let's jump into it. Hey, Dave made it. Thanks, Dave. It's been a while. It's good to see you. All right, Triple Crown says, I have 3 months to establish residency in Florida before filing bankruptcy for Texas medical debt. During that 3 months time, can the creditor sue or serve a summons? So what Triple Crown is talking about here, and there is a follow-up, it says, or can they garnish wages during that 3-month time period? So if you move to a new state, you have to live in that state for what the bankruptcy code says is the better part of 180 days. So that's legal speak for saying you've got to be there at least 91 days in order to be able to, for that court to have jurisdiction. So in this case, move to Florida, you're going to have to live there for 91 days before you can do it. So the question is, can they sue you or garnish during that time period? The answer is yes, they could file a lawsuit. I mean, if they know where you are, if you moved, they can absolutely file the lawsuit. If they already have the judgment, they can absolutely do the garnishment. So you want to keep an eye on that. If they file the lawsuit, you could file an answer to it. Most jurisdictions, if you file an answer, there's no way they're going to get a judgment that quickly in 3 months. And so you could buy yourself some time until you get to where you need to be able to do the garnishment. So, or to stop the garnishment. So that's what I would recommend, is just kind of keep an eye on it, because they absolutely could do that. So, all right. Kim says, how long does it take credit cards to sue me after I stop making payments? Usually, so the normal collection cycle is once you stop making payments, they'll handle in-house collections for about 30 to 90 days. They may then get a outside collection agency to help, but at 180 days or 6 months from the final payment, the law requires the creditor to charge it off. Now, charge off doesn't mean that they can't still try to collect on it. It means that they're counting it as a loss on their books. But what a lot of credit card companies will do is they'll then sell it to a junk debt buyer for pennies on the dollar, or they may keep it in-house, like American Express. They don't sell their debt. They just continue to try to collect on it. So you're looking at least 180 days. I can tell you most creditors, I mean, it could literally be years. The most aggressive is American Express, and I see them usually file suit about a year after the payments are not paid. But the others, it could take much, much longer than that. All right. Sean says, what is needed to show proof of a debt? And thank you for all you do. Thank you, Sean. As far as showing proof for a debt, I mean, it kind of depends on whether we're talking about just out of court or in court. Let's talk about in court. If they have filed a lawsuit against you, to be able to prove the debt, they have to be able to show, there's usually two legal theories that most creditors go under, either a breach of contract or what's called an account stated. Breach of contract is where they have the original agreement, they have your signed application, and they're able to show here's what the terms are, and they have a witness who can bring that in, who can authenticate the document. Now, this in the old days, it used to be they would send you an application, a credit card company would in the mail, you'd sign it, send it back in, and then they would scan that and they actually had it. It's rare that you see that anymore because usually they're just signing up over the internet. So you go online and you fill it out and submit that. And so they can show that, or what they often have to do now is they have to show through an account stated theory, they have to show essentially a course of dealing between the parties, where they will show a bunch of monthly statements. They're going to show charges and payments and that kind of thing to establish that you've done that over a period of time. The account stated theory, though, does require, at least in my opinion, it requires a significant amount of statements showing that. Often they kind of get lazy on this, and they'll provide you just with the charge-off statement, which often just shows a balance, doesn't show any payments, doesn't show any specific charges. That's not enough. That doesn't show a course of dealing. That doesn't show that you consented to those specific terms. So those are the kinds of things you need to look for. If it's a breach of contract, they've got to have the agreement. There's got to be a contract for you to breach. If they don't have that, they're going to have to go with the account stated, and then they need to show an extended course of dealing between the parties. So that's something to take a look at. All right. Matt says credit card charged off account, sent a 1099-C with a G code. They zeroed out the balance on the credit reporting agencies. I dealt with the 1099-Cs with the IRS. Now, many months later, the credit card company is reporting that money is owed again. So if the account was charged off, like I said in the last question, charge off doesn't mean that they are barred from collecting it. The 1099-C, they're saying that the debt was forgiven. So to me, that's a bigger deal than the charge, just saying it was charged off. Because the 1099-C is saying, hey, it is, we have forgiven this debt and we're officially, now they're wanting you to treat it as income. Part of the equation would be is if you actually use that 1099-C if you filed it with your taxes, many months later, they're reporting it. If they're reporting, I would file a dispute to the credit reporting agencies. I would provide a copy of the 1099-C. Now, when you log into, TransUnion, Equifax, Experian to submit the dispute, they all give you the option to submit documentation. I would submit the 1099-C to show that they are done with this, because they shouldn't be able to do that again. So I would file a dispute. And then if it doesn't come off at that point, I would find an attorney who deals with FCRA or Fair Credit Reporting Act type claims to see if you have some type of balance there. So, all right, let's see. Marilyn says, how do you handle situations where you want to file bankruptcy, but you live with a significant other? Does their income get added into the bankruptcy? Great question. So if a lot of it will depend on if the significant other is your legally married spouse. Because if you're married, and particularly in Arizona, where it's a community property state, both spouses do not have to file together. But we do have to disclose and account for income for both couples. So, for both individuals in the marriage. So and this becomes important when you're trying to qualify for a Chapter 7 bankruptcy, because in Chapter 7, we look at the means test. So we're going to look at household income, whether both spouses are filing or not. And so if just one spouse is filing, we look at both incomes to determine whether you qualify. Now, the only caveat to this is if people who are separated, you don't have to be legally separated, but people who don't live together anymore, but they're still legally married, they don't require us to consider both incomes at that point. I always say that the other, your spouses, their income is counted, but it's not like they're filing for bankruptcy. It's not going to show up on their credit or anything like that. So Marilyn had a follow-up question. Do I suggest debt settlement over bankruptcy, Curadebt as debt settlement company? I'm not familiar with Curadebt specifically. The question there, debt settlement can be effective, but I have also seen it where people try to settle debts and it actually damages their credit worse because it just lingers. And each month they're getting hit with another, every 30 days on the credit report is showing a delinquency. If the amount of debt you have is manageable and the accounts can be settled fairly quickly, if you something where you can go in, get them settled out within less than 6 months, then I would say debt settlement is not a bad option. I do have concerns, like I said, that sometimes I think that people need to be pretty realistic about what their ability to settle the debts is. And if it's not something that happens quickly, then the bankruptcy brings some structure to it. It stays on your credit for 10 years, but truthfully, most people recover from the bankruptcy within about 18 to 24 months. Like FHA and VA, they'll do regular mortgage loans again 2 years after a Chapter 7 filing. Other lenders are 3. So you'll recover from that sometimes more quickly than if you just have these accounts lingering out there forever. As far as the debt settlement companies, that Curadebt, I don't know them specifically, but I think it's important that people understand what they do. Because sometimes I feel like maybe what they say they do and what's actually happening is not clearly understood. They essentially act as as a forced savings plan, and they charge you for it. So Freedom Financial, they do this as well, where they sign you up, they pay you you pay them a fee. They say, look, you pay us X amount of dollars each month. They take their fee out of it. They put the rest in a savings or like an escrow account type thing. And then when they build up a balance that they feel is high enough that they can reach out, they'll then reach out and negotiate with your creditors and try to resolve it. The problem I've seen with this on more times than I can count is your creditors are not on board on this. Often they're not even aware that this is happening. And so I've seen these people who have put a ton of money into a debt settlement type company. They paid a lot of money, and all of a sudden they just start getting hit with lawsuits right and left, and they end up having to file for bankruptcy anyway. So I'm always a little wary, unless it's something where there's just minimal amount of creditors. You're dealing with less than 5. I think it's worth at least looking at all your options. Talk to the cure debt people, but maybe you'll have a consultation with a bankruptcy attorney and get an idea of what they have to say. So, all right, let's see. Alex is back. Thank you for Alex for supporting the channel as always. Talks about some FDCPA cases I've worked. So the FDCPA is the Fair Debt Collection Practices Act. And what it is it's a law that protects people from abusive creditors. And it gives rules to creditors of how they have to treat people. They have to treat people fairly. With the FDCPA, I can tell you that they're the kind of things that I actually end up filing lawsuits about. The fact patterns tend to be pretty egregious. Sometimes you'll see FDCPA lawyers out there who will file over pretty insignificant violations. The typical things I see are, consumers who have maybe settled debts or paid them off, and then they get sued again by a creditor, or they start collections again after the debt has been settled. I mean, literally the client's paid money and then they continue to try to collect on it. I just got a brand new case that I personally helped the client. That they got sued by the creditors. We negotiated essentially what we call a walkaway. Case was dismissed. There was a release, a settlement agreement. And then here we are 2 years later, they are sending collection letters to this client saying, go, pay us the money or else. Probably one of the most egregious ones that I had. I represented a school teacher, an elementary school teacher. The debt collector somehow got the telephone number to the teacher's classroom and would just light up her phone all day long, get her on the, she'd have to answer it because it's ringing. The students are hearing it. And teacher was just humiliated, in tears, and it caused a big problem with her employer. We got a big settlement on that one because it totally violated the FDCPA, and really sympathetic situation because, it was like a first grade teacher. She's having to deal with this rather than teaching the kids, and it's all kinds of problems. So the FDCPA cases are kind of fun because it's kind of where we get to go back and hold the creditors accountable. So Matt, thank you for sharing that and for being here and participating tonight. So let's see what One Tough Cookie has for me tonight. Can I request an original contract signed by me from Capital One lawyer firm, and how do I do that if I can? Yes, you can redo that. You can do if there's been a lawsuit that's been filed, you can submit a formal what's called request for production of documents. If you click in the chat there, you're going to see that link to my Consumer Warrior tutorials. I have one specifically about written discovery is what it's called, and it shows you how to do that. I always tell people you always got to be careful what you ask for when it comes to written discovery. And you've got to remember that, like in your situation, the plaintiff, so Capital One, they bear the burden of proof. If they file the lawsuit, they have to prove their case. You don't have to disprove it. And so to me, when I'm defending a case, the fewer the credit documents the creditor has, I'm just like, great, let's do this. If you don't have documents, you can't prove your case. And so but I get the urge, what you're saying there. The urge is like, well, you know what? They don't have anything. I'm going to make them prove it. Often what they'll end up doing is if they, like with junk debt buyers, if they don't have it, they'll then go back and try to find it. Or like with Capital One, maybe they'll start digging through and see if they can bring it up. If they don't have it, if they haven't disclosed it, I usually just sit back and say, great, you're going to lose your breach of contract claim because you don't have a contract. You can't even establish it. So, all right, let's see. PYC says, my only income is workers' comp. Everything I own has been paid with that for more than 30 years. Can I file Chapter 7 for credit card debt, keep my house, etc.? I'm 74, single female. So the one thing you need to look at here is one, it kind of goes back to what I was talking about at the beginning of the video here about exemptions. So each state has exemption laws that protects your stuff, and there's different dollar amounts. So like I talked about, Arizona's homestead exemption protects up to $250,000 of equity. It's going to jump up to $400,000 next year under this new law. Depending on which state you're in, they may have like Nevada has a $605,000 homestead exemption. Texas, it's unlimited. Florida, it's unlimited. But then there are states, I think it's Kentucky, it was like $15,000, which I don't know how anybody keeps a home and files for bankruptcy there. So you need to, this is one of those areas where you definitely need to go talk to a bankruptcy attorney in your particular state. I don't know the exemption laws everywhere. And there can be sometimes tricky things, the local ways and local practices that you need to be aware of. So in many cases, you can. Just depends on what the value of like the vehicles, household belongings are, retirement accounts, all that kind of stuff. Those are the kind of things I would recommend. All right, let's see what Millie has to say. What is the reasonable percentage to negotiate for a judgment that was around $1,800 and is around $6,300 now? These are killer when the interest starts going crazy like this with Midland Funding after they're able to pull $400 from a bank account. So they're doing bank levy, bank garnishment, I guess you could call it. So anytime I look at debt settlement and kind of what I think it's going to settle for, there's a number of factors. The fact that they have a judgment, the fact that they kind of got a bank levy on you for $400, it's not going to settle for $1,800 at this stage. That's why if you're going to try to settle, it's better to do it early on. Try it in the lawsuit, before the lawsuit. And I get it. A lot of people aren't even aware these judgments get entered, but usually a lump sum is going to get you a lower settlement. If it were me and my client, $6,300, everything else being equal, I'd probably offer something like the original judgment amount, maybe $1,800 minus out the $400 that they've already taken. It's tough because they're in a position where they have the judgment. They've already gone through the litigation process, and now they're digging. The fact that they got your bank account tells me they're digging, and you're probably going to have to pay a little bit more. So, all right, vegan life. Is there life after BK? It's a deep question for a Thursday evening. Yes, absolutely there is. And, like I said this at the beginning of this one, I don't ever sugarcoat it. There's consequences to filing for bankruptcy. It's going to be in the public record section of your credit report for 10 years. However, you will recover. You'll recover usually within 18 to 24 months as far as your credit score goes. You can get home loans again around 2 to 3 years, right around there. Car loans and credit cards, for good or for bad, they're available almost immediately. Here in Arizona, I routinely have clients go get cars just right as their bankruptcy is ending, and they end up with interest rates around 9 to 11%, which isn't crazy. It's not great, but it's not. I see clients all the time with car loans, some of them 18% plus because their credit's bad. The bankruptcy, what it does do, it brings some structure to things. It also brings some certainty that, like a creditor knows that you're not going to get hit with a bunch of lawsuits for all these credit cards because they're gone. They know that the medical bills and all that are not going to be causing you a problem because they're gone. And so it brings some structure and certainty to the situation. And so absolutely. On average, 1 million people a year file for bankruptcy in the United States, and they do recover, and they recover more quickly than people anticipate. So, all right, let's see here. Triple Crown is saying, do most companies fire employees if they receive a garnishment order or request? Depending, there can be state laws that, from state to state that may prohibit this. I know that most employers are not happy about it. And I can tell you, like larger employers and most employers that use like ADP or something, it's not a big deal at all. They just submit it to them and then ADP deals with it. But if you get kind of a smaller employer, at least like in Arizona, it's a ton of paperwork. And so it can be kind of annoying, and it could be something that kind of sours a relationship with the employer. But usually that reason alone is not sufficient to terminate someone. But, like a place like Arizona's at will employment state, they can generally fire you for almost anything and even for nothing. So that's kind of how that works. Also, I'm not an employment lawyer, so take that for what it's worth. So, All right, we'll do that. That'll be good. A good place to end for tonight. But hey, thank you everybody for checking in. Go ahead and, like I said, check out the Consumer Warrior community. We're going to start ramping up some more master classes here in the coming week, and I'd love to hear the topics. If there's something specifically you want me to do, kind of deeper dive on, I'm happy to jump into that. Go ahead and sign up, or some of the tutorials. Those can be of a big help. But I appreciate you all checking in tonight. We'll catch you next week.